Constitution now comes under direct attack. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Ever since the United States Supreme Court closed its remarkable 2021 term, the enemies of ordered liberty have been wailing like banshees. When they contemplate the cases the court is going to take up next term, they caterwaul even louder. Now, two Ivy League law professors have proposed a direct frontal attack on the Constitution in the name of social and environmental justice and equity for their favorite victim groups. Society must abolish the Constitution, or at least strip it of all its meaning and power to ensure the rule of law. They seek openly to establish a government not of law, but of the mob. Or perhaps they covertly seek to establish an rule by themselves or by oligarchs who would take their advice. Before we get into details, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, including this t-shirt that I have selected for today, which reads, "Freedom isn't free." That's right, it isn't. And again, before I go any further, I have to address all of you who are scratching your heads and asking, "Ban what?" A banshee is an otherworldly creature, traditionally female, who wails to give warning that somebody is going to die. Usually that somebody is a member of the family of the person or persons to whom she directs her wailing warning. A man can act like a banshee too, and that is how these two professors are acting. So once again, let's paraphrase Jack Nicholson as Colonel Nathan Jessup, USMC, in A Few Good Men, and ask ourselves, Whiskey Tango Foxtrot, are these assailants against the Constitution? In fact, I'll do one better. I'll quote God himself. "Who is this that darkens counsel by words without knowledge? Now gird up your loins like a man, and I will ask you, and you will instruct me." Job chapter 38, verses 2 and 3. Ryan D. Derfler and Samuel Moyn are law professors. Derfler from Harvard, Moyn from Yale. These two have collaborated before. Their separate resumes detail their leftist credentials. Now, I'm not going to call them solid. Solid isn't the word for someone who, like these two, founds his argument not on rock, but on sand. But they are consistently leftist in their outlook on the law and how the law should read. Look at where Professor Derfler has published his work: Atlantic, Jacobin, The Nation, The New Republic, and The Washington Post. Professor Moyn has published at similar venues and also in the Wall Street Journal, and maybe they need to re-examine their guest column policies. Now, look at this title by Moyn. "Not Enough, Human Rights in an Unequal World." In other words, these two men are woke. Or at least they're still men, the last time anybody checked. Being woke, they want to destroy ordered liberty, because that liberty lets people do and say things they do not like. They also have come to the logical end game of attacks on ordered liberty and a constitutional republic. A republic governs itself and its citizens and lawful residents according to the rule of law. That doesn't satisfy these two professors. They know, of course, that arguing the Constitution won't make recent Supreme Court decisions any less valid. So now they attack the Constitution directly. So on August the 19th, 2022, Professors Derfler and Moyn published a piece in the New York Times, and its headline, "The Constitution is broken and should not be reclaimed." Reclamation in this case would mean repeating the decades-long campaign that gave us a Supreme Court that produced so many of the precedents they love. Those include, of course, the precedents the current Supreme Court has overruled. The professors cite Roe versus Wade, of course. Oddly enough, they cited an obscure 1918 case that weakened state child labor laws. Hammer versus Dagenhart, 247 U.S. 251, 1918. But they refer also to other disasters in the 2021 term. Now let's see if we can't guess what these might be. New York State Rifle and Pistol Association versus Bruin. Check. Carson versus Macon. Check. Kennedy versus Bremerton School District. Check. West Virginia versus Environmental Protection Agency. Congratulations. You all just won the Cupid doll. And they definitely cited, though not by name, 2 forthcoming cases that Students for Fair Admissions have brought. They didn't cite Moore versus Harper, the North Carolina redistricting and elections case, but they might as well have done. Now, having laid out their complaint against the Supreme Court, they tacitly acknowledge that the court simply obeyed the Constitution. That, they say, is the problem. The centuries-old text of the Constitution binds society to the past, and to that they object. In other words, all law can and should change to whatever the mob of the present moment thinks is fair. Doerfler and Moyne occasionally avoid telling us what form our governing institutions should take. They do plump, first of all, for a right to end a pregnancy, and I guess they mean whenever the pregnant person wants, for any reason or no reason. They want to forbid any child to work for extra money, even if said child wants to. And finally, they want to discriminate against meritorious individuals who are members of groups they think have privilege. Didn't I talk about that 2 days ago? The 8 precepts of woke. Sure I did. But they leave clues to the kind of society they want to build in their hyperlinks. So when they speak of a quest for real freedom, they link to a 4-year-old piece touting socialism and giving a new reason for it, which is that freedom to them means you don't have a private boss anymore. We are all everybody else's bosses. Likewise, when they, perhaps temporarily, want the Constitution to be more amendable, they link to a very interesting page with 3 particular leftist amendment proposals. Some of these amendments use very general language, which makes it harder to figure out what they really mean. But as nearly as I can tell, these law professors at Yale, Cornell, and Boston University, respectively, propose 1. A democratic political economy, most probably socialistic, with free hospitals, free clinics, free this and that, and primacy of the environment over personal convenience. 2. To propose constitutional amendments by either a 2/3 vote of both chambers of Congress or by simple majorities on 2 successive readings, 1 federal election apart. Such amendments would go directly to the people for ratification by national popular vote coincident with midterms or presidential elections. And 3. Direct and immediate national initiative and referendum. Then, Doerfler and Moyne admit, or avow, where they really want to head. I quote, "In a second stage, though, Americans could learn simply to do politics through ordinary statute rather than by staging constant wars over who controls the heavy weaponry of constitutional law from the past. If legislatures just passed rules and protected values majorities believe in, the distinction between higher law and everyday politics effectively disappears." Unquote, Doerfler and Moyne. To arrive at their utopia, they would do one better than those wanting to pack the court. They propose packing the Union, in other words, to admit new states. But how to create them? They link to a method that appeared in the Harvard Law Review in 2020. First, they propose shrinking the federal district to the National Mall and essential federal buildings. Now, what those are, they won't say. Second, create as many new states as necessary out of the territory thus renounced from congressional exclusive control. Remember, Article 1, Section 8, Clause 17, the District Clause. The authors set no limit on the number of states to create, nor any minimum territorial size. So that could mean creating a plethora of new states, each of which is no bigger than a city block. And how then do they propose amending the Constitution? By 1, transferring the powers of the Senate either to the House of Representatives or to a fairly apportioned body. 2, expanding the House so that the minimum number of representatives per population would be 1 representative for as many people as you have in the least populous state. 3, electing presidents by direct national popular vote. And 4, amending Article 5 so that the ratification by those states encompassing a majority or supermajority of the population would be enough to put a proposed amendment into force and effect. Now, Dörfler and Moyne have another nutty proposal in case that plan is too complex. Now, before I get into it, I want to shout out to a sponsor that can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me so many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Now, whether you just want to collect rare and unique coins or take advantage of the business opportunities that company provides, they can help you learn to lead an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Anyway, if Dörfler and Moyne want to make it simpler, they actually propose that Congress itself, by statute, revise the way it does business. Presumably that means transferring the Senate's powers to the House and making the Senate no more than an advisory body. It would function, in other words, like the British House of Lords or the Canadian Senate. The proposal these professors cite also includes enlarging the House to 600 members. And to make sure the Supreme Court couldn't interfere, strip the Supreme Court of its jurisdiction over how Congress works. Dörfler and Moyne then mention again the kinds of new laws they want their new Congress to propose. I quote, fundamental values like racial equality or environmental justice would be protected not by law that stands apart from politics, but, as they typically are, by ordinary expressions of popular will. And the basic structure of government, like whether to elect the president by majority vote or to limit judges to fixed terms, would be decided by the present electorate as opposed to one from some foggy past, unquote. But here's the rub. The only way to ensure that would be to strip the court of its jurisdiction over all laws. Then instantly the Bill of Rights is of no moment. Congress could legislate away its protections by a simple majority vote of the House, not the Senate. And any president who stood in the way would face removal by a single House vote, because the House would inherit the Senate's power to try, not merely bring, impeachments. So, right even to have a religion, gone. Right to keep and bear arms, gone. Right of security of the person, household papers, and effects against unreasonable search and seizure, gone. We go to writs of assistance, general search anywhere and everywhere for anything and everything warrants. Double jeopardy, triple jeopardy. Just compensation for takings, What just compensation? Maybe the only just compensation is no compensation. You see what I'm driving at? Well, Mr. Christopher Wright, 2 days ago, dashed off a very angry reply. He said the Ivy League is broken, it should not be reclaimed. Now, he was talking about the Derfler and Moyne article in the Times. Wright correctly observes that majorities could swing right as well as left. But he misses something. A leftist majority could and would protect itself by the method they are now using with their January 6th committee, which is to say, to propose bills of attainder and ex post facto laws against their conservative foes. Now, remember, a bill of attainder is a law declaring a particular person to be an outlaw. Literally, it's what happens when the legislature singles out a person or persons for punishment. Trial in a bill of attainder case, if one can call it that, would take place in the House, and the House, the Judiciary Committee, or this January 6th committee would indict all conservative voters. The House would then confirm it, and after that, the new internal security forces, or in German, Schutzstaffel, would arrest and imprison all conservatives. An ex post facto law prescribes punishment for conduct prior to its passage. By definition, it is retroactive. Bingo! The House passes a law against something Donald Trump did or allowed and makes it retroactive. Again, cue the mass arrests. Wright misses one other thing. How does the Harvard Law Review select those who write for it? What shall we make of any law school that admits the kind of immature children who write such screeds as the Pact the Union proposal and actually get it into the law review? How dare anyone propose to carve out states no larger than city blocks just to ram through constitutional amendments effective, absolutely repugnant to the rule of law? How dare any institution admitting such people call itself a law school? Law? Harvard Mob Rule School, they mean. To add this consideration is to reinforce Christopher Wright's conclusion that the Ivy League is broken indeed. Now, reclamation might still be possible, but it would take time. Better to include colleges and universities among the parallel structures that Stephen Turley, PhD, and others have proposed. That might also have to include a parallel council on accreditation. So be it. Any council that continues to accredit a law school that lets students publish that kind of goo and drivel in its law review should lose its power to accredit. More broadly, any such proposal is a proposal for oligarchy. 5 kinds of government or states of society exist: monarchy, oligarchy, democracy, anarchy, and the republic. Monarchy can be hereditary or not, in which case most people call it dictatorship, but it amounts to the same thing. Now, I don't list those societal states in that order by accident. In fact, of the first 4, oligarchy is the stable one, and all the other 3 tend toward it. Even a king, queen, field marshal, president for life, or more simply, leader, governs by consent of a small body. Now that body could be secret or open, but when they find the leader a liability to them, they also find that leader expendable. We saw that happen to Emperor Nero of Rome and to Nikita S. Khrushchev of the old Soviet Union. The only reason it didn't happen to Adolf Hitler is that the oligarchy's enemies arrived to arrest them all after Hitler killed himself. Likewise, democracy survives, if at all, as an outward form only. An elite inevitably forms to make sure the people vote the right way. Anarchy, by definition, is never stable. Sooner or later, a small group organizes troops of loyalists who enforce their governance. But the republic is stable. It gets its name from the Latin res publica, the public thing. Law and the rule of law keep it stable. The Constitution guarantees a republic. Dörfler and Moyne don't want that. They say they want democracy. They're actually going to get oligarchy, and maybe that's what they really want. Now, how likely is anything like this to pass? More likely than you think. Already, we have on the table proposals to make the District of Columbia, as it now is, a new state. Some proposals occasionally add shrinking the federal district to the National Mall and a handful of departmental and other buildings. Then, instead of retroceding the remaining land to Maryland, they propose reorganizing that land as a state. Now, from that to the Harvard Law Review proposal is a small step. Why stop at one state? Make more than one. The Harvard Law Reviewers occasionally avoided simply creating new states from the most populous states now existing. See, that would require the consent of the Congress and the legislature's concerned. Now, why are we even seeing a proposal like this, and why is it getting us attention? Because evil must advertise. Evil doesn't have to advertise its plans as evil, and it can even call itself good, but evil must advertise. God himself surely decreed this. So evil can only effect such a plan after advertising it first. The Dörfler and Moyne New York Times piece is an advertisement of and by evil. So was that Harvard Law Review piece, but that didn't get nearly the attention that maybe it deserved. Those who respect liberty and the republic must thank God that this advertisement of evil came this close to midterms. We now know the real issue of midterms. The enemies of freedom have just put the republic on the line, and anyone who wants to protect it, you know how you need to vote and for whom. Link in the description of the article and the conservative news and views. I'm also going to leave a link to the awesome CNAV Store and to oursilverlives.com, as I also mentioned. And if you like what you've heard, you can like this video. On the end screen, I'm going to leave a subscribe link and also links to other videos I've done about the concepts I've mentioned today. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.